We have three very distinguished speakers. I will keep their introductions short in order to enable each of them to speak for 20 minutes, and then there will be a 15-minute question and answer period. Bless you. One more. Judge Goldstone is currently serving as a justice of the First Constitutional Court of South Africa since 1994, sorry. Just want to make sure you all were awake. He has been serving as a justice of the Constitutional Court, which has been charged with the responsibilities of interpreting the new South African Constitution. He is a member of an international panel established in 1997 by the government of Argentina to monitor the Argentinian inquiry into Nazi activity in the Argentine Republic since 1938. He is the author of numerous articles on international law, international human rights, and war crimes. And furthermore, he served as the chief prosecutor of the United Nations International Criminal Tribunals for former Yugoslavia and Rwanda. Professor Schabas is the director of the Irish Centre for Human Rights at the National University of Ireland in Galway. He's the author of 18 monographs dealing in whole or in part with international human rights law, and has published more than 170 articles in academic journals, principally in the field of international human rights. As a point of interest, his writings have been translated near and far near, Russian, Chinese, Spanish, German, Japanese, Farsi, Arabic, Portuguese, and Albanian. As the Israeli here, I asked why not in Hebrew. These writings have been cited in judgments of many of the world's leading courts, including the United States Supreme Court. He is indeed a highly distinguished scholar. Our third panelist, Mr. Andre Surena, his career reads like a novel, if you will. He has had an incredible variety of jobs in the State Department, for having personally negotiated the largest ever spy trade between the East and West in Berlin. He served as the general counsel to the multinational force and observers in keeping the peace between Egypt and Israel based on the 1979 peace agreement. He has developed State Department's modern extradition treaties and asset forfeiture agreements, and we are indeed very fortunate to also have him. I kept it short. Sir.
Well, good afternoon. In the short time available to me, I would like to discuss the manner in which the United Nations Torture Convention, as it's commonly called, has influenced the approach of the United States with regard to with regard to torture, the oldest and most despicable of policing techniques. It goes back centuries. I will then turn to consider the effects of 9/11 on this approach and the role of international organizations, in particular human rights organizations, in this context. I would suggest that the starting point of any discussion of the role of international law and torture is the recognition that international law prohibits torture and other cruel or degrading treatment, and importantly, this prohibition is both absolute and non-derogable. There's no recognition in international law for what I would suggest are absurd scenarios such as ticking bomb theories. I've yet to hear any evidence of a ticking bomb or somebody who planted a ticking bomb yielding great information as a result of the use of torture. If anybody has information like that, I'd be very glad to hear it. Few countries have suffered more at the hands of terror attacks than Israel. The response of the Israel Supreme Court to torture has remained uncompromising. Recently, in a Harvard Law Review, the president of the Israel Supreme Court, Aaron Barak, wrote the following. He said, "While terrorism poses difficult questions for every country, it poses especially challenging questions for democratic countries because not every effective means is a legal measure." I discussed this in one case in which our court held that violent interrogation of a suspected terrorist is not lawful. Even if doing so, I repeat, even if doing so may save human life by preventing impending terrorist attacks. An Irish judge, and Ireland's not unused to these sorts of problems, Judge Kingsmill Moore said, "To countenance the use of evidence extracted or discovered by gross personal violence would, in my opinion, involve the state in moral defilement." Strong words. In the United States, too, the United States Supreme Court has been uncompromising. As far back as 1952, the court said this: use of involuntary verbal confessions in state criminal trials is constitutionally obnoxious, not only because of their unreliability. And I stress this, in repeated cases the United States Supreme Court has referred to the unreliability of information yielded by the use of torture. They are inadmissible under the Due Process Clause, even though statements contained in them may be independently established as true. Coerced confessions offend the community's sense of fair play and decency. So here to sanction the brutal conduct which naturally enough was condemned by the court whose judgment is before us would be to afford brutality the cloak of law. Nothing would be more calculated to discredit the law and thereby brutalize the temper of society. The United States of America was one of the champions of the 1948 United Nations Convention against torture and other cruel, inhuman and degrading treatment or punishment. It's interesting, in light of the United States' present attitude to the International Criminal Court, that in 1988 the United States supported universal jurisdiction against those who were suspected of violating the provisions of the Torture Convention. In its report to the Senate on the question of ratification of the Torture Convention, the State Department report read as follows: the United States strongly supports the provision for universal jurisdiction on the grounds that torture, like hijacking, sabotage, hostage-taking, and attacks on internationally protected persons, is an offence of special international concern and should have similarly broad universal recognition as a crime against humanity with appropriate jurisdictional consequences. Provision for universal jurisdiction was also supported by the State Department in view of the fact, as it said, that the government of the country where official torture actually occurs may seldom be relied on to take action. In its 1999 report to the United Nations Committee Against Torture, the United States State Department again spoke out and said this: torture is prohibited by law throughout the United States. It is categorically denounced as a matter of policy and as a tool of state authority. Every act constituting torture under the Convention constitutes a criminal offence under the law of the United States. The United States is committed to the full and effective implementation of its obligations under the Convention throughout its territory. That was the official approach of the United States, and the United States led the rest of the free world in this and other matters relating to fundamental civil liberties and human rights. It is safe to assume, I would have thought, that the use of torture is held to be immoral in all societies and is regarded as abhorrent by the overwhelming majority of people all over the world. During the apartheid years in South Africa, it was my misfortune to witness at first hand some of the consequences of torture. I had the misfortune, and perhaps it was to my benefit as a South African judge in those days, to actually interview detainees who had been tortured. And to see human beings in that condition, I can assure you, is a very unpleasant experience. In the past couple of decades, there has been, as we know and as has been talked about today, this upsurge in the horrors of international terrorism. The United States, prior to 9/11 of 2001, generally considered itself a remote target. The homeland of this country was considered safe, and that, of course, changed dramatically and tragically on 9/11. There has been a significant increase in the use of torture in attempts to counter modern terrorism. What is of deep concern is that this is also happening in the democracies, and the United States is certainly not alone in that regard. It is also significant and a matter for reflection that the use of torture is usually accompanied by demonizing and dehumanizing the victim. The sorts of photographs the infamous photographs from Abu Ghraib, I would suggest that similar events are almost impossible to think of were it United States citizens who were at the receiving end of that sort of treatment. Experience in both democratic and oppressive societies demonstrates that law enforcement authorities will use torture and will use degrading treatment unless they really fear the prospect of being exposed publicly, or even more importantly, being punished for ordering or allowing the use of torture. The only efficient way to deter the use of torture is the enforcement of its prohibition through political, legal, and law enforcement branches of government. There are few countries where that is the policy. Until recently, the United States was the role model leading the democratic world in outlawing torture. At least in theory, there was zero tolerance for torture in this country. Governments that permitted or tolerated torture were strongly criticized in the annual State Department reports on human rights. And those reports were, and I hope will continue to be, important. Governments modified their conduct for fear of being criticized in the annual human rights report that was put out by the State Department. They knew that criticism in those reports could affect loans from the World Bank, their standing with the International Monetary Fund. It had a deterrent effect. Those reports often put oppressive governments to shame, and as I say, that acted sometimes as a deterrent. It is a tragedy of vast proportions that the United States has abandoned that leading role. Indeed, today, the growing tolerance for torture and degrading treatment of people held in detention by officials of the present administration is being used to justify far worse treatment in some oppressive societies. Let me now turn for a few minutes to human rights organizations, and particularly international organizations. I would suggest that in the context which we are now talking about, that there is a growing role in this area for human rights organizations, for human rights law, for international tribunals. It is not surprising and perhaps obvious that it is in the democracies that human rights organizations play the most effective roles. In open societies, they are free to go about their business, unfettered by oppressive security police. Their appeal to the public conscience at times cannot be ignored by democratic politicians. I would refer, for example, to the recent call by United States health professionals to prevent torture and the abuse of detainees in U.S. custody. And it's important because, unfortunately, in societies where torture has been tolerated, the medical profession has to a very large extent been complicit in allowing that to happen. The Organization of Health Professionals said that as health professionals whose work is devoted to promoting health and well-being, we believe that torture and cruel and inhuman or degrading treatment are ethically and morally repugnant wherever and whenever they are inflicted. As the American Medical Association's Code of Medical Ethics provides, physicians must oppose and must not participate in torture for any reason. They said we are particularly disturbed by the pattern of reported abuse, physical torture such as beatings and shackling and stress positions, and psychological torture such as mock execution, sleep and sensory deprivation, prolonged isolation, forced nudity, cultural and sexual humiliation, use of dogs to instill terror, threats of violence or death against detainees as their loved ones, and more. And who would have thought 3 or 4 years ago that those words could have been spoken by a United States professional organization about the conduct of the United States? They concluded by saying the US military has identified the deaths of at least 28 detainees as confirmed or suspected homicides. We are deeply concerned that even as evidence of abusive treatment accumulates, current policies may continue to authorize the use of psychological torture, and that these methods may still be in use. Physicians for Human Rights, which I'm proud to be associated with, has recently published a comprehensive report on the use of psychological torture. They have called on, and Human Rights Watch more recently has called on the Congress to set up a truly independent inquiry into the use of these methods by the United States forces in Iraq and elsewhere. They've called for an independent commission to investigate, carry out its oversight responsibilities, and enact appropriate legislation. I received only this morning an article which appeared last week in the latest edition of the Journal of the American Medical Association. And they comment on the recently published medical practices by the United States Army Surgeon General. They've said that following the release of these documents and reports, and those were reports that were issued under the Disclosure of Information Act, in June 2005, the Assistant Secretary of Defense for Health Affairs released new ethical guidelines for all healthcare personnel, including physicians, nurses, and medics. The new guidelines are troubling, however, because they do not come to terms with the participation of physicians and other healthcare professionals in officially authorized interrogation practices that are absolutely prohibited by international human rights law. So again, here there's an elision. There's another hole being created, and we've heard today of holes in a number of areas of United States law and policy. They say, while the new Department of Defense ethical guidelines apply to all healthcare personnel, we focus on how the guidelines enable physicians to facilitate and monitor abusive interrogation practices and subvert well-established ethical duties to support health and human dignity. It's perhaps on the optimistic side, but I think we should recognize that human rights organizations, particularly in this country, but international and domestic human rights organizations, have assumed an importance that would have been unimaginable only a decade ago. It is to their credit that the United Nations Security Council established the ad hoc criminal tribunals for the former Yugoslavia and Rwanda. I think Sharif Bassioni will agree with me that but for the pressure, but for the call from the human rights organizations, egged on by people like you, the United States, the United Nations Security Council took some action. It is a direct consequence of their shaming the leaders of the Western world into doing something in response to the ethnic cleansing that was then going on in the Balkans. They have played a similar role with regard to the establishment of the International Criminal Court. Without the push, without the hue and cry that they set up, the international community, I would suggest, would not have set up, as it has now, with the support of almost 100 countries, a permanent international criminal court. And I was very happy to learn earlier today that the International Criminal Court has now issued its first indictments against the leaders of the Lord's Resistance Army in Uganda. If the United States is again to become the leader of the free world and the prime respecter and protector of fundamental human rights, NGOs in this country and civil society in general have a crucial role to play. In conclusion, I would suggest that the recognition of the human dignity of all people is fundamental to democracy. Torture is the most extreme example of the denial of human dignity. That is what makes it abhorrent to decent people. It is essential that the American people follow the call made this week in the United States Senate, an uncompromising call for all forms of torture and degrading treatment to be absolutely prohibited, and for the human dignity of all people to be recognized and protected.
Well, it's sort of customary in conferences like this for speakers to thank the hosts and to congratulate them on organizing a nice conference. Usually by that we mean the hotel was nice and there was someone at the airport with my name on a sign, and I expect to get a good meal when this is over, and that sort of thing. I want to congratulate the organizers, particularly Michael Scharf and Case, but for something a little different. Leila Sadat, when she spoke, talked about the image of the United States abroad. I'm not an American. I'm a Canadian citizen, and I'm a resident in Europe. And I think I can confirm, I don't want to speak about the image overall, but certainly about the image of American academics abroad, is that they tend to be too docile and submissive. And this despite a country where you have academic freedom and where the freedom of expression is protected by the Constitution. And so that's why I want to congratulate Case and Michael Scharf on organizing this conference, because it takes a certain amount of courage to do such a meeting that provides a forum that is so critical of your own government. And I dare say that there are law schools in the United States where the deans and the administration wouldn't look favorably on having such a meeting. So hats off to you for doing this. It's great, and it's the best of what academic communities and universities are all about. I want to start with a little story about a trip I made to Iran about 5 years ago. I went there for a conference organized by the United Nations Training Institute, and while I was there, I was asked to give a seminar for people in the Iranian Foreign Ministry on whether or not Iran should join the International Criminal Court. They have a committee there that was studying this, and they were considering the pros and cons, and they asked me to come and talk to them. And at one point, the chair, who was a mullah, had the dress looked just like the Ayatollah Khomeini, and he said, "Look, can you give us one good example of why Iran should join the International Criminal Court?" And I said, "Well, I'm a law professor, so I have to give you a hypothetical. I know hypotheticals got bad press today, but I said, I got a hypothetical for you. You're just sitting there in Tehran one day, minding your own business, and some helicopters from a superpower come flying over the desert and, do some terrible things on your territory, and then they go back to their aircraft carrier in the Gulf, and you can't get at them." I said, "It's just a hypothetical." By this time, the guy's got a big smile, and I said, "If you join the ICC, you're part of a cartel of, now 99. At the time, we didn't quite know, but I said a minimum of 60, which was the required number for the ICC to operate, who are bound by treaty with you to help prosecute those who were responsible for attacking you." And it has a very big protective effect. And he liked the argument, and he said, "I'm going to use that when I go to the Majlis and have to try and argue why we should ratify the ICC statute." And then someone in the room put up his hand, and he said, "Well, but we have a few problems with the ICC statute." He said, one in particular, every year here in Iran, we have executions of women for the crime of adultery, where they are buried up to their shoulders, and they're stoned to death. And he said, it's not that many, but it's a significant number. And the way he described it, it was clear he wasn't proud about it, but he said, it's a fact of our law, and this happens. And he said, we need to know, would that be a crime against humanity? Would that be, more particularly, the crime against humanity of torture? And we discussed this a little bit. I didn't want to give him a too definitive an answer because I want them to ratify it. We can tell them it's torture after. But more seriously, it does work where everyone's been saying we have to give mature, serious legal analysis. There is no precedent that I know of. I don't know of a case from the Yugoslavia Tribunal saying that 4 or 5 cases a year of burying women up to their neck and then stoning them to death for a crime amounts to torture and would be a crime against humanity. And so I wanted in my presentation today just to look at some of the issues in the interpretation of the crime against humanity of torture and of the war crime of torture, but I think more specifically the crime against humanity of torture by the current tribunals, to see if they can give us any answer to that, so that we understand a little more what torture is. Well, actually, the case law, there haven't been that many judgments from the tribunals. I'm speaking of the Yugoslavian Rwanda Tribunal. I don't think the Special Court for Sierra Leone, which is operating but hasn't yet given a final judgment, and hasn't, I don't think, used torture in their indictments. This was pointed out, incidentally, when they tried to get Charles Taylor from Liberia, and it was said that they would have had a much stronger argument if they'd actually put torture in the indictment, because then they could invoke the Torture Convention, and they didn't. And for that reason, it was a weaker case that they made to have him transferred to Sierra Leone for the trial. In the case of the Yugoslavia and Rwanda tribunals, while there have been indictments and convictions, I don't know that the case law has added a great deal to what we already know and what we can glean from reading things like the definition of torture in the ICC statute. I mean, they use essentially the same definition. It's drawn from the Torture Convention. It talks about the infliction of severe pain or suffering, physical or mental. It can be an act or an omission, and it has to be carried out with a prohibited purpose. It's one of the exceptions in the the catalog of international crimes where motive or purpose becomes relevant to the definition of the crime. So the purpose has to be, and this comes straight out of the Torture Convention, it has to be obtaining confession, or it can be punishing or intimidating or coercing the victim or a third person, or it can be discriminating on any ground or against the victim or a third person. And that's essentially the definition, and if we were to take that definition and apply it to our problem in Iran, you might say, well, it seems to fit. That's inflicting severe pain or suffering, physical or mental, for a prohibited purpose. The problem is there's a little rider at the end, and it says that this is not does not apply to a lawful sanction, and that's an escape clause, I suppose, for the Iranians. But it's not a satisfactory answer, and it's one I've looked for more authority on. I think it's a difficult one to interpret because it surely doesn't excuse the imposition of terrible sanctions in the course, even though they're technically lawful, and that international law has to be able to intervene somewhere. If drawing and quartering was a lawful sanction in a society, surely that wouldn't escape international criminalization as a form of torture. And I think there is authority for this in such sources as the special rapporteurs of the Commission on Human Rights talking about some of the Islamic penalties. The amputation, I think the special rapporteur on Sudan got in trouble some years ago when he criticized Sudan for penalties of amputation. And he said, well, that violated Article 7 of the Covenant on Civil and Political Rights, even though it's a lawful sanction. Now, one way of addressing this is to say that the definition in the Torture Convention and in the Rome Statute doesn't correspond to customary international law because the lawful sanction exception isn't there in the Covenant. Maybe you can get around it that way. I think maybe it's better to say that this lawful sanction business is not to be treated absolutely, and that in fact there is a certain room for peering into what are lawful sanctions and addressing that within the context of torture. Otherwise, the prohibition of torture and cruel, inhuman, or degrading treatment or punishment seems to me has no sense if you can't actually look at some of these horrible sanctions that are meted out, even though they're perhaps in some perverse technical sense still lawful or allowed under law. So it's sort of to that question that I think we have to turn in looking at this issue of the executions in Iran. There is significant authority for the idea that carrying out executions amounts to torture or cruel, inhuman, or degrading treatment or punishment. There's some authority actually going back to the case that others cited this morning, the Allstarter case, the justice trial at Nuremberg. And Nazi jurists were found guilty of crimes against humanity for their excessive imposition of capital punishment. Well, now that wasn't just that wasn't an absolute prohibition of capital punishment, but they clearly weren't uncomfortable with the idea that they could look at what were lawful sanctions, because the excessive use of the death penalty by the Nazi regime was carried out according to law. And of course, the beauty of that Allstarter judgment is that it says that there may be Nazi law, but there's another law that you have to apply, and that you will be found guilty of crimes against humanity for carrying it out. I think there's also a kind of a logical argument that we can look at that is always a problem in dealing with the issue of torture, can it be torture? I don't think we have a problem with saying it would be torture to cut off people's hands and legs. So why does it cease being torture if you cut off their head? Can it be, we wouldn't have any problem, I think, saying that hooking people up to electrodes and putting jolts of electricity through them would amount to torture, and there's lots of precedent for this. So why does it cease being torture when you turn up the electricity high enough to kill them? And then it becomes a lawful sanction. Poisoning them. We know that there's a prohibition on the use of gas under international humanitarian law. Well, why does it become acceptable when you put people in a room and put the gas in there and kill them with it? So I think looking at it just in a logical sense that there's something difficult about this, and we've had, people have referred to the famous memos that talk about, for it to be torture, it has to cause organ damage or death. But if it's death because it was ordered by a judge, does it cease being torture? Is it only when it's death carried out by Lindy England or something in a prison rather than carried out in Huntsville, Texas, in another prison in another part of the world? Well, there's also a fair amount of authority that certain aspects of the imposition of the death penalty amount to torture or cruel, inhuman, or degrading treatment or punishment. So there's authority from the European Court of Human Rights and the Human Rights Committee and so on such things as the death row phenomenon, that is holding people for a lengthy period of time, on the method of execution, and on the issues of the seriousness of the crime. And that's what they were getting at in the justice trial in the Alstott case. But there's also authority for the idea that imposing the death penalty per se amounts to torture or cruel, inhuman, or degrading treatment or punishment. The main authority for that, judicially, is, of course, Richard Goldstone's former court, the South African Constitutional Court, which in its judgment in the Makwanyane case in 1995 found that the death penalty in South Africa was a violation of Section 11 of the South African Constitution, which prohibits torture. And that's what they said in the judgment. Justice Goldstone was on leave. He was in The Hague at the time, so he didn't sit on the court. But I doubt he'd disagree very much with it. I don't know that he's ever expressed a dissenting opinion since then in disagreement. Coming over yesterday on the plane, I had the pleasure, well, first of all, I had to read through the Continental Airlines flight magazine, which I wasn't ready for this. There's a big picture of Michael Scharf. And then I got to all the reading I brought with me, including a recent issue of the New Yorker magazine, which has an interesting article on Justice Kennedy and his reference to international law. Probably some of you have seen it. But in there's a reference to Richard Goldstone as well, where he says that the most conservative justice on the South African Constitutional Court is probably more liberal than the most radical justice on the U.S. Supreme Court. And I thought that was interesting. And maybe that means that it's a little time before the U.S. Supreme Court is going to get to where the South African Constitutional Court was in 1995. But when I read the recent judgment in Roper and Simons, which of course declares unconstitutional the execution of people for crimes committed under the age of 18, and I look at the arguments and read between the lines, it seems to me they're saying, come back in 5 or 10 years with a good test case and some good arguments, and we'll give you the whole thing. That's just the logic of it. This morning, Jeff was talking in his remarks. I wanted to intervene this morning in there, but there wasn't enough time, about the issue of torture with respect to killing in war. And he sort of put the killing part aside and said, well, that's just war. That's part of war. But torture prohibited and has to be prohibited. And I thought that he was, and we spoke about this at lunch, that he shouldn't concede that point, that in the future killing in war will also be prohibited. We're just not there yet. And we have in the past other things that have been prohibited in war. We prohibited the use of certain weapons. And you can see it historically. Hollow-tip bullets and gas and crossbows and poisoned arrows. And we haven't got to nuclear weapons yet, but we will get there. And, maybe it sounds, maybe I'm being too much of a legal positivist. I actually don't think it's being a positivist. It's just understanding that the theory of the law, where we should be, we're just not quite there. And we're not there with the prohibition of war or with the prohibition of killing in war, but we are there with parts of it. One of them is torture. And somehow we've managed to put that thing behind us, like we've put slavery and other forms of ill treatment behind us. We haven't quite got there with the death penalty, but it's my belief that in the near future that will happen, and that in 50 years from now, if someone suggests imposing the death penalty, you'll hear lawyers saying, you could be prosecuted for crimes against humanity. And I think that that's what I would have liked to tell the Iranians. I'm going back there next month, and if I get my courage up, maybe I'll explain that to them, that they might be able to get away with it for a few more years, but that long term they're on the losing end of this curve. I'd like to conclude with another thought about these issues of torture and more generally about abuse of prisoners in Abu Ghraib and in Guantanamo, and the kinds of justifications we've seen for them. There was talk in the last panel about the memos, and I wanted to mention another memo by another Goldsmith, by the way, that people could usefully study here, because it gives an example, I think, of a government that at least is getting better, more balanced advice. Lord Goldsmith in the United Kingdom wrote a memo to Tony Blair 2 years ago about the issues involved in going to war in Iraq. And ultimately came down in favor of it, but in a very nuanced and cautious way. The memo was released a couple of months ago, and you can get it on the internet. Just try Goldsmith memo on Iraq, and it'll pop up somehow in Google. But it's a much more balanced thing. It even entertains such original ideas as the fact that Blair might be prosecuted for the international crime of aggression, like people were at Nuremberg. Now, it admits, which I think is correct, that this was a remote possibility, but it's an example, I think, of a government being well informed by its advisors, even if we might disagree with the advice that was finally given. It's more balanced than some of these memos, which I think are, I refer to this as the Tony Soprano school of lawyering. It's like, Tony Soprano goes out and, drops the guy in the concrete overcoat into the river, and then he goes to his lawyer and says, can you talk your way out of this? And that's what those memos look to me like. It's not a matter. I sort of agree with the speaker earlier. You said that you don't think it would have changed very much, and I sort of agree with that, because I think it's ex post facto justification and everything. But I do think that a big part of these issues of prisoner abuse and everything are part of a more general syndrome, or a more general problem that is particular to the United States, and that is, you're not very nice to prisoners generally. It's not just the people in Guantanamo. It's not just the people in Abu Ghraib. You have too many of them, more than 2 million at last count. They say there are only 9 million prisoners in the entire world, so the United States accounts for somewhere between 20 and 25% of people who are in lawful detention. And yet you only have 5% of the population of the world. You're way over the top. You're way over the top compared with other developed countries. And I think that that this is a problem that goes beyond a bunch of people that we might not like in the administration. It's not just neocons. It's a far more general problem about the American justice system, and this is just the ugliest tip of that iceberg. Thank you.
Killing large numbers of people.
Can I push something? It's on. Well, there's several points there. I actually was in Berlin when the Red Army faction was still active. Baader-Meinhof was no longer active. But the Red Army faction was sort of the successor in interest. And as part of my portfolio, I had to pay attention to those things. And I objected strenuously at the time, and I think maybe still, to the concept of terrorism. What Baader-Meinhof, Red Army faction, Red Brigade were doing, in my view, was criminal. Seriously criminal, but criminal. Early on in the discussion about this, there were some who were so eager to describe terrorism as something new, as a criminal matter, that they would take the crime of, let's say, murder one, and add a political element to it. to make it a terrorist act. And all that would do is make it more difficult for the prosecution to make the case. The penalty wouldn't necessarily be any greater, but now, if this terrorist act of murder were to be proven, one of the new elements was to prove the terrorist intent. So I never liked that idea. And it didn't really matter, in my mind, whether it was Heinz Q. Public or one of the leaders of industry in Germany, or even Al Haig. One of the problems, I think, one of the differences between that and Al-Qaeda, and what I'm going to say now is something that I think revealed itself over time, is that the leadership, which appears to have claimed responsibility for the 9/11 attacks, said they were declaring war on the United States and its people. So I don't really know what that is, but I think it's somewhat different from the Red Army faction and the other terrorists. I didn't mention Black September and the Palestinians, but I think they're also in that category.
Well, you could, I mean, I think it's an interesting observation, a comparison between them, but if you look at the terrorists in Ireland, for example, they were both targeting, you know, if they got close enough to Thatcher, they'd take a shot at her, and they did it a couple of times, but they would also kill significant numbers of people in indiscriminate bombings in urban centers. So I don't know if it's, I mean, it's an interesting observation about them, but I don't know if it changes the legal qualification. The debate about whether humanitarian law or human rights law, or neither of them, as Andre suggests, might apply, has been an active one in Ireland as well. And I never bought into the people, most of them what I'd call in the human rights community, who have been so anxious to make humanitarian law apply. It's always struck me that that actually isn't helpful and is far more protective of innocent civilians to say, it's true, it's governed by the criminal law, but the human rights law sits there as a screen protecting them, and civilians are better protected under human rights law than they are under humanitarian law. So it's in the, if you're just looking for the, if you're looking at it in a rhetoric or in an advocacy sense, it's better to get the human rights law in there.
Well, I was going to agree with part, at least, maybe more than part, of what you said. The IRA, for decades, has been trying to get the British government to recognize them as prisoners of war. And the British government, for decades, has been treating them as common criminals.
Well, they haven't, because when they finally settled the whole thing 7 years ago, they treated everybody as prisoners of war and let them all out of jail when the conflict was over. So it's a mixed. You can't.
I'd love to hear from Andre. Remind us that that our convener has given us these principles to where we have homework here. And one of the issues that's come up, Bill, you raised this, and Richard, in your comments, sometimes depending upon the category, and it even comes through in my remarks, right, whether is torture a crime against humanity, torture is a war crime, a violation of torture under the Torture Convention or under customary international law. And one of the things that came out of the tribunals, and I'd love to hear you, Bill, talk about this, and maybe Richard, is in the Kavachka case, they say that you don't have a state action requirement for torture, because torture under the laws of war should be considered differently than torture as defined in international human rights law. I sort of perked up when I read that. It's a very interesting development in their jurisprudence. It would mean that all these contractors that are running around that aren't government actors might actually be scooped in under that kind of torture definition. And I just wondered if either of you wanted to speak to that development in the tribunal, or what you think about it, or how it relates to Principle 4 here, which talks about people acting under color of law. Thank you.
Well, if you look at the cases of the ad hoc tribunals, you find that there's kind of I think, a confusion between first of all, the different categories of international crimes, and then the general prohibition of torture, which we find in the Torture Convention. And, of course, you have torture dealt with in the international criminal legal regime, as both a crime against humanity, where there's a requirement also that it be widespread or systematic or one of those thresholds, or as a war crime, where you have another dimension that has to be either an internal or an international armed conflict. Whereas a single act of torture per se, irrespective of whether it's part of a widespread or systematic attack and so on, also falls under the Torture Convention. In the early judgments of the Yugoslavia Tribunal, they said that torture had to have this state component, which they borrowed from the Torture Convention. And then in subsequent judgments, it was said, well, you don't really need that, and don't mechanically transpose the Torture Convention to international prosecution, because the Torture Convention has a paradigm of the individual and the state. And so, of course, torture has to be committed by an individual acting on behalf of the state, whereas it's different with respect to crimes against humanity and war crimes, where that's not required. And now, where is Sharif now that we need him? This is, I think, I don't know. I don't want to stretch it too far to say it's an ongoing debate, but I know that Sharif has written recently arguing for reintroducing the state policy or the state plan component into crimes against humanity. Somewhere, the state's got to be in there. Now, that doesn't mean that if they're not subcontracting it, the state's not involved. And I think you get at the contractors through that. You know, you can draw a line, and there's a thread that goes back to the state. Of course, Sharif's view, I think, to be fair, is a minority opinion right now. And the general trend in the case law is to say, forget about the state involvement, go for the non-state actors, and we're at a situation now in international criminal law where you really can't distinguish the application of crimes against humanity to the Gestapo and the application to the Hells Angels and to serial killers. It's become a very broad concept.
About the Crips and the Bloods. Do you know the Crips and the Bloods?
The Crips and the Bloods and the star-bellied Sneetches. Yeah.
No.
We have time for one more question. Just a minute. Hang on. Wait, just a minute. Oh, excuse me. Need a microphone.
Hello.
To Professor Schrafer, you mentioned in your introduction that you had spoken to the Iranians, and you gave them the hypothetical as to why they should join the International Criminal Court, that helicopters from a superpower were going to drop some explosives on their city or something like that. If that superpower, and therefore they would have collective action under the International Criminal Court. But what happens if that superpower was not a signatory and denied the jurisdiction of the International Criminal Court? Can you go back and are you going to go back and correct the Iranians on that, or are you going to just leave it as it is?
Oh, it's not an oversight on my behalf. The International Criminal Court applies to crimes committed on the territory of a state that joins the International Criminal Court. So if a superpower, hypothetical superpower that hasn't joined the International Criminal Court violates the laws or customs of war or commits genocide or crimes against humanity on the territory of a state that has, then the International Criminal Court has jurisdiction, and we don't care whether the superpower has accepted the jurisdiction. It's irrelevant. Actually, if a hypothetical superpower commits a crime against humanity in Ireland, well, we can prosecute them under our own law, so why can't we give jurisdiction to the International Criminal Court? We don't need to ask their permission to prosecute them for committing crimes on our territory any more than the superpower asks anybody's permission when they prosecute nationals of other states on their territory for committing crimes there.
But how one gets to defend it before the court is another question.
That being said, thank you very much.